DBA disputes are going up and up and up. Why is that? You probably know. We are now in the 11th year of the Iraq-Afghanistan conflict, and a lot of the DBA cases that have been kind of going through the claim system are now maturing to the point where there's got to be final decisions made as to extent of disability, the final disposition of the cases, and a lot of times these are cases and issues that are ripe for final hearing. So that's the reason. But it is a disturbing trend because our staff is not increasing. The ALJ staff is not increasing. We have a limited, finite budget to handle a greater workload. So let's go to the next slide. And I'm going to go and show you the other end. How many disputes get resolved in the last 4 years? And I'm happy to say that in 2012, we wound up resolving more disputes than in the last few years. And we at our claim staff can do whatever that they can do within our system. But if it is not for you all, the employers, the insurance carriers, and even the defense attorneys to say, yes, let's try to get these cases resolved early. We can't have this type of results. So this type of results, I think, is in part a reflection of, yes, we now have a full complement of staff. And we got some really, really good new staff in the last 6 months of 2012 who are experienced, and they're getting into doing more of the dispute resolution work, and that shows in this statistic as well. But we are doing more dispute resolution than ever before. Next slide, please. So this next slide shows you, though, this is where I think the difference is. This shows you the number of disputes that are out of the total in the previous slide, the number of disputes that are resolved at our level versus at the OALJ. You see that the OALJ resolutions went down in 2011. That was the worst of their caseload burden. I think they've kind of they've shed some of their older cases that have been languishing, and they've either by settlement or by decision have gotten them out of the system. But look at the blue bar. That shows the number of disputes that are actually accomplished at the OWCP level. Why is this good? Please go to the next slide. The reason it's good is that the amount of time that it takes to do a resolution at the OWCP level, what I call the informal level, is much lower. It's almost 50% less time. Look at 145 days in 2009. It's gone up a little bit in 2010, 2011, 2012. We reverted that number, that trend, and we've gone down. So it takes about an average of, 5-6 months to resolve a dispute at the OWCP level versus at the ALJ, which if we were talking, and this is overall disputes, if you go to trial, it takes over 400 days. That's a huge amount of time. And time means money, both in terms of the money that the claim is going to cost, the litigation cost, and your attorney costs.
We issue recommendations after a conference within 10 days. So it's a quick process. You'll get a response. A lot of times the examiner will give you a response that same day. You may ask them what it is in the conference, but they may have to review it before they make that recommendation. But it's a very quick process. A delay is not helpful. So one of the things that we do encourage is all the parties bring all the information to the conference. They're usually scheduled with enough time for everybody to have notice. So if you're at the conference and you say, well, I've got this other medical opinion, he's going for an IME tomorrow, or we're waiting for this medical report from last month. If we can get those things taken care of beforehand and even reschedule the conference so all the information's at the table, it helps to have a good recommendation based on the facts and not to linger about, which can cause mistakes and other issues. So next slide. Formal litigation at the ALJ. After the informal, or at any point in the case, either party can request referral to the ALJ. The LS-18 form is the trigger. When we receive that form, we'll refer it to the ALJ without delay. We refer them within 10 days, just like recommendations. So if an 18 comes to our office, we're sending it to the ALJ and notifying the parties so that it can get put on the docket as quick as possible. Part of that process is formal discovery, medical evaluations, depositions, written interrogatories, discovery requests. These are the issues that your attorneys are going to handle and put together. It's a lot more time consuming than the informal dispute resolution, but also a lot more evidence is brought to the table, so the ALJs have a good basis for their decisions. There's also settlement opportunities through the Office of Administrative Law Judges via the mediation or settlement programs. I think there's you use that the relationship with the judges to see if a case is right for that, and they're more than willing to accommodate most of the time. We will also if the case is right, try to provide that at the district level if it's possible before it gets referred to the ALJ. It's a full APA hearing. The claimant has his day in court. There's a court reporter. He's before a judge. He's sworn in. All the evidence is on the record. There's nothing left out. So all the parties should be satisfied that the judge has all the information necessary to make a good decision. And then afterwards is a binding decision. Unlike informal resolution at the district level, which is a non-binding recommendation that either party can reject, the ALJ's decision is a binding recommendation, and if benefits are awarded, they need to be paid within 10 days under the Act, and it's appealable, and but it's binding on the parties. If you'll go to the next slide, Jared.
Yes. Do you have a number on how many go through informal conference hearings and then take it to the ALJ? Is that a very small percentage?
It'd probably be a pretty large percentage if, that's, yeah. Yeah, we don't track that. I haven't done it. Yeah, we could probably figure something out to figure that out. Yeah, well, no, I mean, there's not a lot. It kind of depends who the recommendation is in favor of. So no, they're not always popular recommendations, but I do find in my office that I've got a good balance of people from claims backgrounds, from other backgrounds that understand the inner workings, what goes on both sides. And, I feel that they do give a good middle-of-the-road, based on the evidence, recommendation.
We, on the defense side, oftentimes forget that dreaded P word, the Section 20 presumption. You have to recognize that going into any issue, into any claim, the claimant already has, in quotes, an upper hand, so to speak. They've already established half the battle of establishing compensability of a particular issue or particular subject because they have the benefit of the presumption. All they have to show is that, hey, there's something wrong with me, and there was something at my work that caused it to be wrong with me. And that's it. That's all they have to do. So at that point, you're responding to an issue or a situation or a subject that the claimant has already established, so to speak. So instead of focusing on, okay, well, how can I deny it? Let's look at it from how can I accept the claim? What should I do to address it real quickly, maybe nip it in the bud, so to speak, and get the person to a particular doctor if it's a medical issue. Let's be realistic here. It's not uncommon for folks working overseas, if they see a friend of theirs get blown up, they may have a psychiatric issue. They may be a little depressed. They may be a little anxious. And so maybe you get the person to a psychiatrist or a psychologist for a few sessions, and they're okay, and they can get back to work. But if you deny it, if you say, no way, that would never happen, I can't believe it, then oftentimes that's going to send that person to an attorney, and voila, you have already established a claim, and they're contacting the Department of Labor. Oftentimes, in terms of checking emotions again, what happens during the morning before you get to work can oftentimes cause you to have that attitude throughout the day. I know that if there's more than 5 people in front of me in the Starbucks line, I'm a little pissed off, and I want to, the first call I get in the morning is deny, deny, deny. So you want to call me probably after 10 o'clock after I've already had my coffee. But again, checking emotions at the door, having a Zen moment for a second, taking a deep breath, I think will go a long way in helping you out there. Alan, did you want to add anything on the attitude section?
When Mark and I were talking about this topic, and thanks again for rubbing me into this one. Mark's over 20 years practicing. I'm almost at 30. When we meet claimants in the course of a claim and take their deposition, and you always give them the opportunity to, unload. Is there anything else you want to tell us? Is there something you want the carrier to know? They always respond. They respond with, they either are pissed at their employer because they feel abandoned. As soon as they got hurt, nobody calls them anymore, never send flowers, there's no gifts. But their pay is stopped, and they feel like they're just awash. Or that the adjuster is, fill in the derogatory term of your choice. They say they'll call me back in 24 hours, they never do. They said that they will get me this information, they haven't. There's always a gripe in the litigation process. They are irritated either with the carrier or the employer, and that's a significant fueling factor in how they're behaving in the claim. And I believe that the initial contact that a carrier has with an injured worker really does set the tone for the claim. They have an axe to grind, and that impedes the ability to resolve disputes and ultimately settle cases. That's what I think leads them to lawyers a lot of the time, because they don't feel like they're hearing anything that they need to hear on the other end. So I think that attitude at the outset of a claim really is going to guide the balance of the claim going forward. We do have to assume that some people are really hurt, that they really do want to get well, and they really do want to get back to work. And if you treat them all like they're liars, you're going to have a negative result from that. So it is a bit of golden rule of treating them the way you would want to be treated if you had been injured at work yourself.
Just a little bit about us, since some of you may be familiar with us, some of you may not. As I said, we're a medical management company working with employers, attorneys, insurance carriers to cost-effectively manage medical-related issues. We came from years of experience in the risk management industry and a belief that basically we could provide a higher quality of service than that which we'd come to expect over the years from other managed care providers. Coming from this background, we formed to offer claim administration-oriented services that recognize the very particular and sensitive conditions that are involved with workers' compensation claims management. So, in an IME, the approach is very important. Just like a film requires a screenplay, an IME requires a methodology to be successful. Too often, there's a lack of focus and quality in the deliverables that are produced by many of the claims management services, and we believe that doesn't have to be the case. Again, focus and quality. Those are important because focus here is the primary ingredient, and it means having a plan, an actual plan when you go out for that independent medical evaluation. And then quality is ensuring that that plan is followed and or adjusted as necessary to ensure that the actual report or deliverable that we get is useful. In the end, our goal is ultimately just to gain information that we can then act upon. So I'll dig into the approach that we've found most productive and what we believe is an overall effective methodology for this process. So we're all familiar with IMEs, and there's certain factors that separate a quality IME from a mediocre one, or even in some cases, a detrimental one. I'm sure we've all experienced that from time to time. Whether you're here as an adjuster, or an attorney, or a risk manager, or whatever capacity you're here, I think that this information will at least sort of highlight or remind you of those things that we should be focused on when looking at an IME. So the main purpose of the IME is to determine the cause and the extent of disability. This is a specific yet broad purpose. And what I mean by that is it's specific in what the IME is trying to address, but the aspects that it is trying to address will not necessarily occur at the same point for each claim. So, for example, a claim may have been accepted and an IME may be requested at the outset to kind of determine the extent of disability, the extent of the injury, and what treatment is likely necessary going forward. But even that same claim, it may have been accepted and treatment rendered, but months or perhaps even years later into the claim, the treatment seems to stall. And it's in these types of cases where an IME can really provide us that direction we're looking for. So when an IME is requested, there are steps that can be taken to make the IME more effective. We want to have that focused approach like I talked about. And it's necessary because no two IMEs are created equal. I know that sounds like you've heard that before, but unfortunately from time to time, it seems like we just throw a blanket approach to any old IME. So we want to address the specific issues of the claim, and in our experience, many of kind of the big box managed care companies really do what any of you in this room could do on your own, and that's you just kind of get a bunch of medical records together, you mail them to a doctor, and you say, hey doc, I need a report. And really that's kind of it. So anyone can just select a doctor out of a hat basically and have those records reviewed and a report given, but that's a gamble that we don't need to take. We need to have a plan. And our plan for an effective IME is to create a roadmap, manage the route, and arrive at our destination. So, creating the roadmap, you'll notice as I go through this that this is kind of the most extensive step, and that's because preparation is so important here for an IME. So creating a roadmap starts when knowing when to request an IME. And it's appropriate to request an IME when you don't have an accurate picture of the medical factors that a claim involves or in some cases doesn't involve. With an IME, there is something specific that we are trying to answer. This is important. We're looking for something pretty specific. It could be determining the extent of an injury, the anticipated length of time on disability, or to even just obtain work restrictions that allow an employee to return to work in some capacity. The goal is to get an opinion from the evaluator to get a clear picture of the action needed on that claim, and in this pursuit, We actually must provide guidance to the evaluator to ensure that our specific needs are addressed.
To set the scene, I wanted to highlight a couple of the specific wage loss issues that the labor market survey tackles, and then we'll jump into the key components of your ideal home run report. So a couple of those things. First, when we're looking at a claim where we have established disability and the need for a labor market survey, we want to take a look at true employability. And what I mean by that is the report needs to analyze all the skills, and really only the skills and experience that the employee possesses, so that you're taking a look at only the jobs that he or she can actually go out and apply to and get that job. On the one hand, we won't be identifying astrophysicist jobs for somebody without a high school education, but a lot of times, if you're applying the skills correctly, there are jobs that pay more than minimum wage that somebody can do. And then the true labor market, this is a little bit more complicated, but I just wanted to essentially say that we want to understand and take a look at the entire labor market that somebody can find a job in. And in some cases, that does include Defense Base Act jobs overseas, but I'll talk a little bit more about that later. So one of the important factors, and really kind of the starting place for a labor market survey, is the vocational expert who drives the report. And there are a couple key factors in selecting the right pilot. And first, we're taking a look at licenses. So you want to make sure that your vocational expert has a CRC, or is a certified rehabilitation counselor. And that just means that they have a master's or doctorate, and they've passed the national examination, and they've got some experience in the industry. Oops, I actually want to go back. But it's not just enough to have that license. You actually need to have a lot of experience in the industry as well. And not only that, CRCs work in all different areas of voc rehab, so you want somebody who is used to working in workers' comp. For example, a CRC who works primarily with individuals transitioning from correctional facilities isn't going to be familiar with the requirements of a workers' comp labor market survey, and more so, somebody who does labor market surveys for state claims may not be familiar with the requirements under the Defense Base Act. Since our cases rely so heavily on the labor market survey and expert testimony, it can be really detrimental to a case to have somebody who doesn't have that experience be deposed by opposing counsel. So take, for example, we have an injured worker who has work restrictions instilled by his treating doctor and some different restrictions instilled by the IME doctor. Treating doctor says he can't go back to work overseas. IME doctor says he can. Opposing counsel is going to ask the expert witness something like, well, how can you say that this claimant can go back to work overseas when the IME doctor says that he can't? And an inexperienced voc expert might try to interpret the medical opinions or comment on the validity of one medical opinion over the other, but really the job of the voc expert is to analyze all medical opinions and then identify jobs based on those medical opinions. It's not the job of the voc expert to take one opinion over the other and say it's more valid. And then contacts, a labor market survey is really only as strong as the contacts or the quality of jobs. So case law tells us that we actually have to include real job listings. We can't just take labor market statistics and say, well, in this year there's predicted to be this many of this type of job, and it on average pays this amount of money. It's supposed to be a snapshot of the actual labor market. So this can be really difficult under the Defense Base Act when you're trying to look at Defense Base Act jobs, because a lot of employers won't release wage information. It's hard to get in touch with them. So you really have to have those pre-built contacts with the defense contractors in order to get information about those jobs and ultimately include them on the labor market survey.
In litigated cases or in any matter, and in any forensic manner, a vocational specialist should complete a labor market survey obtained through specific methodology. We can't just basically do what we want, so to speak. And hopefully this evaluation is going to assist defense counsel, insurance company, employer in making informed decisions. That's the whole purpose of the labor market survey and the vocational evaluation. We have no interest in what the claimant obtains, what a claim settles for, et cetera. Our goal is to help you make an informed decision on the claim. Some of the different factors and variables were documented and relied upon by opposing vocational specialists. And we're going to talk about some of those variables. There are varied earning capacity models which may explain some of the differences in many of the reports, and also the records reviewed may vary between specialists. That's why, to dovetail what Andrew was talking about, we don't need every medical report in the file. It really isn't relevant, hospital records, how much someone was voiding in a day while they were in the hospital. It's important for us to have that op report and know what the physical restrictions are. So it really isn't necessary to give us, unless we're doing a life care plan, the banker's box of records. We just need the records relevant, and we do want the same records that the opposing specialist reviewed. This is identified in peer-reviewed research by our friends Rick Robinson in Jacksonville that he completed in obtaining his PhD. But some of the factors that should be noted in the report, some of the variables are previous employment, personal social history, education, any medical factors, reason for referral and referral source, any literature that's referred to avocational factors, which is basically hobbies. Sometimes hobbies can relate to a transferable skill. Any psychometric testing either completed by the vocational specialist or by a neuropsychologist is relevant to the labor market survey. Any behavioral observations, if you do a face-to-face interview, any behavioral observations. It could be as simple as somebody having the ability to use a smartphone. You would know they have, decent cognitive abilities. Military service, very important. In the labor market survey, often we'll note if an employer has military hiring preference, which may place the individual a little higher in the pecking order of applicants. It also may place that individual in a higher, if it's a range. For example, a government job that pays between X and Y, if there is prior military service or or a degree, that's going to place them in a higher pecking order in that range. Any activities of daily living, any medicational factors, of course, the transferable skills analysis and economic factors. Again, not all specialists address all of these individual variables in the report. And this was identified in research in factors that should be considered or identified. Of course, in the evaluation, we should include the labor market survey. Andrew discussed what is a valid and reliable labor market survey. Past, present, future medical care could impact, the plan. Wage earning capacity, not necessarily indicated by the claimant's choice or the specialist choice. I recently did a railroad case where the vocational specialist on their own just determined that the claimant was only capable of part-time work. There was nothing whatsoever in the medical records that indicated the person could only work, or the claimant could only work part-time. The specialist just decided that was what the claimant wanted, so they only identified part-time jobs in the labor market survey.
If you have a great a CT scan or an MRI or a nerve conduction study or something like that, that's when the judge starts to say, I'm tasting some good things in here. This guy really, threw some things in there. So x-rays, MRI, CTs, EMG, NCVs. I'm probably missing a couple, one or two, but basically you put those in your salad and the judge is gonna, he's gonna enjoy it a little bit more. A negative example, I guess, would be if you have an IME, great IME report, saying the guy can go back to work full duty, but the radiologist reads it as an explosive herniated disc, then that's worthless. That's not winning. The judge is going to say, yeah, there's a presumption, claimant met his burden, but the employer carrier did not rebut the presumption because even though they had an IME doctor saying that wasn't causally related, the objective testing, which is read by a radiologist who doesn't even know who the claimant is 99% of the time, they're just gone through scans, they don't know who Joe Smith is, so they have no dog in this fight. If they're reading the report against your IME, he's got to have a really good reason, unless he's a neuroradiologist or something, but unless he can counter what a bad radiology report says, even the good IME report isn't going to get you the good salad. So, spice it up a little bit. The chicken guy, yeah. The chicken, okay. I like the chicken too. I know what a bunch of you guys are saying. You're saying, like, I'm never going to get any good evidence from a treating doctor. I mean, come on. So my salad's not going to have any chicken in it or anything interesting like that. What we've found is that you don't need to get the treating doctor to totally fold. I mean, you're not going to ever probably 100 cases to say that, he agrees with the IME doctor. But there may be some normal objective tests out there. There may be a normal neurological examination or a normal range of motion testing. Pick out 3 or 4 things that your IME and your treating doctor agree on and ask those questions, and then all of a sudden you can start to spice. We already got the lettuce, we got the tomatoes and some strawberries and peppers and whatnot. Now we're throwing in a little bit of chicken here, and now your salad's starting to taste really good. And at the same time, the difference between Iron Chef, I guess you make your own thing. The good thing about a case is that you get to throw a little salt with cross-examination. You can actually contaminate the claimant's salad too. So make sure you at least get some concessions out of the treating doctors. Even if you think it's not possible, there's always something they agree on, and you need to highlight those. Okay. No one ever likes to ask the guy right before lunch a lot of questions. So I don't know if Miranda's still here or not. But a query I had when we're talking about treating doctors, and I think Alan mentioned it a little bit earlier, is I know in the Jacksonville district usually the claims examiners are going to side with the treating doctor, but if you can poke a few holes in them, they may flip over and you can use your IME report if it's a recent one. Are there any trends, anybody in the other districts that you see something different than that, where they favor IME reports, or is it pretty much all, treating docs? 'Cause I think the reason why we're here is to share some of this knowledge. So if anybody has any trends from other districts as far as treating versus IME, how they weight them, speak now or forever hold your peace. All right, I guess not. It's just the guy before lunch. At least I have a food-themed presentation. Okay. Favorable voc. I like this the picture analogy because what Sean and Carla and Nancy and the good folks with the voc do is they're like the squirrels, really. I mean, they're gathering up all those jobs, they're gathering up all those nuts out there, and that's great. And that is a part of, it's not just one part, it's part of this whole salad. Remember, the salad is all together.
The topic is burn pit exposure. I don't know how many of you are familiar with this. If you're not, this is kind of an introductory, if you will. And if you haven't heard of it, you will if you're in the DBA arena. It's area and exposure within the framework of the Defense Base Act that is gaining momentum, if you will, in terms of claims. An analogy for the Vietnam era, which is what, 40 years ago, is Agent Orange. And this is similar to that in terms of its latent bodily injury. November 25th, 2012, there's a settlement for Iraq War awarded $85 million in personal injury against KBR Halliburton. So that should get your attention. That's not me, that's the award that was awarded against KBR and Halliburton. And these were 12 National Guard soldiers who became ill after serving in the war and awarded an $85 million settlement. The contractor is Kellogg Brown and Root, and in their lawsuit, the first concerning soldiers' exposure. Generally, they're civilian contractors, right? Because soldiers are, you would think the liability would go towards the government, and the government, of course, has sovereign immunity. So the soldiers, though, were exposed to this hazardous, they call it TIH, or toxic inhalation hazard. And that was in southern Iraq, and they alleged that KBR was negligent. Specifically, they claimed that as a result of the exposure to sodium dichromate, they now suffer from respiratory diseases. And as you can imagine, there was a great deal of medical evidence presented at the trial, and ultimately they were awarded. I'm sure that this will be appealed. Nevertheless, it does set a precedent, and it does underscore the severity of the exposure and the prevalence. In terms of the prevalence for burn pit exposure, or it's technically known as toxic inhalation hazard, is how prevalent is it? Well, wherever the American military has a camp or a base, they have a burn pit. And a burn pit is really no more than a hole in the ground where they throw all the garbage. And, you know, you might be asking yourself, well, how can a hole in the ground burning garbage really create this kind of a liability, a long-term liability, and potentially a mass tort liability down the road? The thing is that they throw everything in there: medical waste, human waste, plastic, wood that's been coated with, I don't know, fire retardant chemicals, fluids from aircraft, from machinery, from tanks. Anything and everything is dumped in that, and it's then lit on fire, and it burns for months on end. And, you know, this has been going on forever. It's just really come to the attention of medical science and the claimant's bar. So in their personal injury lawsuit against the American military contractor KBR, the lawsuit first concerning soldiers to a toxin at a water plant in southern Iraq, the servicemen alleged that KBR was negligent. Specifically, they claim that as a result of exposure to sodium dichromate, they now suffer from respiratory diseases. Furthermore, they're concerned that the carcinogen, the toxin contains hexavalent chromium, could cause cancer later on in life. Each of the dozen, there was 12 Army National Guardsmen involved in the lawsuit, was awarded $850,000 in non-economic damages and another $6.2 million in punitive damages for outrageous and reckless indifference to their health. So, long story short is that civilian contractors, whether in this case it's a water plant and there was it was contaminated, or you know, and they were responsible for operating a filtration plant or burn pit exposure, as the case may be, they have the same duty of care to these civilian contractors, and that's to operate in a reasonable manner, as a reasonable person would, and avoid these type of bodily injury.
if you remain the contractor on a contract, when it's modified or extended and it is now issued by a non-U.S. government agency, do you still need DBA cover? Or if you're entering into a contract with the UN or NATO or the government of Canada, do you still need DBA? Again, the exclusivity provisions will be enforced by the federal courts, and very strongly so, if it's a DBA case and the DBA employer, the contractor, went out and got the DBA cover. Let me just step back for a second. Just as a side note, the only way you can get DBA cover is to purchase it, for a contractor, is to purchase it from a Department of Labor authorized DBA carrier, or be self-insured. In fact, as best I know, maybe there's one or two self-insureds out there, but not among the big contractors. I think maybe Cornell used to be self-insured for DBA purposes. But outside of, no? I thought so.
The contract with NATO would require?
Well, let me get into that. Let me say this first. You're staring at me. Let me say it this way. You have to have cover, let me just step back. You have to have cover. And you can only get it from a carrier. And if you don't get it from a carrier, then you don't have cover. The kicker in the law is, of course, the contractors, the employers are obligated to secure the payment of compensation. Without that, then you don't have the exclusivity issue. You don't have the exclusivity and tort immunity protections. If it turns out to be DBA, and you didn't secure the payment of compensation, there's no excuses, and the contractor sits and suffers from it. The carrier can also be dragged in, because a lot of times the contractor goes to the carrier and says, what do you think? Is this DBA? And we all write opinions for carriers all the time about whether or not this type of contract, this type of extension or modification, whatever, is this still DBA, and do we need to be covered? So that the fallout from not getting cover is the contractor in the first instance. But then, of course, E&O suits have been developing over the course of time against carriers and their agents and the brokers in order to drag more people in with money to cover this debt. And these tort cases are always very, very, very heavy cases. No matter how heavy the DBA cases are, the tort cases for deaths, et cetera, are usually much higher. All right? So now, if you go back in time, the way that DBA contracts are DBA contracts is, of course, just summarizing, if it's if they're to be performed at a U.S. military base overseas, or if they're signed off on by the U.S. government, the U.S. is a signatory to the contract, or if the U.S. government approves and finances, at least in part, the contract that's at issue. The question of whether it's a U.S. signatory is something that generally is well established and clear at this point, because the contract says U.S. Navy or U.S. Department of State or something like that. But remember, there are issues that do come up. This is the most minor problem in this myriad of problems. But you take the CPA back in the Iraq days in 2003 and 4, when the Coalition for Provisional Authority was running the Iraqi government, I guess running the Iraqi operations, and entered into billions of dollars worth of contracts. There have been cases like Custer Battles and other cases that talked about whether or not the CPA was actually a governmental agency, but for a number of years, the question was, is this signatory part of the U.S. government? Today, these issues still do arise because there's thousands of these agencies. Remember, it's the U.S. government or its instrumentalities or its agencies or whatever, and that can be a long list. Now, how does anybody find out if it's really a U.S. government agency? Well, you go to the website, and you try to figure it out that way. Or if you know better, tell me. Okay. The concept is that you want to show the easiest case when you know you got to get DBA cover. Whether it's a new contract or a transitioning contract, is if the U.S. is a signatory and remains a signatory. The next step up, the easier case for us to determine whether or not these transitioning and new contracts, even if not signed by a U.S. agency, is whether or not they're performed on a U.S. military base overseas.